Most broadly, there appears to be a serious disconnect between the view of criminal justice and its purposes between the courts and the legislatures, and I would say also the general public. What was really shocking to people was the fact that the courts use Section 12 of the Charter, which prohibits cruel and unusual punishment, to knock down very short mandatory minimums for very serious crimes, particularly sex crimes. And I would say it's really shocking to see the Supreme Court strike down the mandatory minimum for child luring, and the Court of Appeal for Ontario strike down the mandatory minimum for sexual abuse of a minor under the age of 16, both of which were 1 year mandatory minimums.
Hello, everyone. My name is Peter Copeland, Deputy Director of the Domestic Policy Program here at the Macdonald-Laurier Institute. Thank you for joining me for another episode of Inside Policy. And I am joined today by Professor of Law Ryan Alford. Professor Alford served as a judicial clerk for the Honorable Robert L. Carter in the Southern District of New York and the Honorable Rosemary S. Pooler of the United States Court of Appeal for the Second Circuit. He practiced in international arbitration, transnational litigation, and cross-border mergers and acquisitions. Ryan is a senior fellow with us here at the Macdonald-Laurier Institute. He works at Bor Alaskans chapter of the Runnymede Society, the National Law Student Membership Group dedicated to debating the ideas and the ideals of constitutionalism, individual liberty, and the rule of law. And he's been involved in several constitutional challenges. Ryan, thanks so much for being with us here today.
Always a pleasure, Peter.
So Ryan, let's dive right in. You recently wrote an article for us stemming from other work you've done on criminal justice that essentially tackles two issues. One is the jurisprudence around mandatory minimums and criminal justice reform more broadly, which is kind of the foil. And the other is how governments deal with the courts that you could say seem in many instances to be hostile to the laws that are being passed by legislators. So there's been much speculation lately about the use of the Notwithstanding Clause as a remedy to judicial overreach, as it is being used in Hack versus Quebec regarding the wearing and display of religious symbols, and Saskatchewan v. UR Pride on gender identity. So today we're going to tackle criminal justice jurisprudence, broader trends in judicial interpretation and judicial power, and then some possible remedies, including the Notwithstanding Clause and broader judicial reform. So I want to start with law and order, though, as it is the way in for you here to this issue in public safety. In recent years, we've seen increases in violent crime, general crime trends, as well. I know these figures from my time in public safety here in Ontario. They've been increasing since 2014, more or less. There have been several high-profile court cases, including Antic and Zora on bail, which were then codified by various pieces of federal legislation, making it harder to grant bail, among other things. And as you note, Ryan, mandatory minimums, they've been either scrapped by the current federal government and others overturned by the court. And in light of this increase in rising crime, Canadians are right to be concerned. So in your work, you speak to the court's treatment of mandatory minimums and other criminal justice laws. Tell us what's happening in the courts in this domain.
Most broadly, there appears to be a serious disconnect between the view of criminal justice and its purposes between the courts and the legislatures, and I would say also the general public. So it's really difficult to see this judicial discourse around crime and justice that seems to be focused exclusively on the rights of people who are accused of crimes, or in the case of sentencing, who have been convicted of crimes. The notion that there isn't some sort of balance to be struck between effective approaches to crime and the natural justice given to people in the criminal justice system, this really seems to be out of balance at present.
Great. So do you have some examples you could draw upon here to illustrate the point? Like, where do we see this?
Yeah, I think most properly we see it around mandatory minimums. I think it's the most salient way to demonstrate it. So in that situation, you have the legislature essentially issuing a policy statement about how various concerns and various goals of sentencing should be balanced, because sentencing is by its very nature something that balances various objectives, only one of which is the rehabilitation of offenders. So you have other concerns. You have the incapacitation of the offender. When they're in prison, they can't commit further offenses. You have deterrence. And most importantly, in my opinion, you have denunciation. You're issuing a very clear statement about the complete unacceptability of particular types of offenses. So what was really shocking to people was the fact that the courts use Section 12 of the Charter, which prohibits cruel and unusual punishment, to knock down very short mandatory minimums for very serious crimes, particularly sex crimes. And I would say it's really shocking to see the Supreme Court strike down the mandatory minimum for child luring, and the Court of Appeal for Ontario strike down the mandatory minimum for sexual abuse of a minor under the age of 16, both of which were 1 year mandatory minimums.
Yeah, and so you note a balancing here, Ryan. And one question is, what is the will of the legislature in creating the policy? How do they frame its objectives? Because when this balancing goes on, sometimes you seem to see the courts emphasizing other things that perhaps take precedence. Obviously, the Charter is there to play that kind of bulwark and backdrop. Against which you can't, legislation can't pass a certain threshold. But what's going on there? Are they taking into account the objectives that the legislator is employing to justify the policy, or assuming others? And how does that factor into the decisions?
Well, this disconnect on the purposes of criminal justice is really fundamental. And I think we're going to get into, in the course of this discussion, really what's at the very bottom of this, where it seems as if the courts see punishment as somehow illicit, or at least somehow distasteful, conceptually. The notion that the offender is deserving of punishment is something that seems like they want to kind of obviate in various ways. And there's also a concern for cruelty that takes on a certain kind of a meta level, becomes kind of a salient meta principle for the courts. But I think we'll get to that eventually. I think that what we're seeing kind of more practically is the legislature, which is politically responsible, is dealing with its constituents, talking about this explosion in crime and how it's affecting standards of living. And they're saying, well, people are asking us why we have this revolving door system of criminal justice, where people who are out on bail are committing crimes, and then they're getting bail again under the system that you described coming out of Antic and Zora as it was codified. And they're responding to this. And it used to be taken for granted. You wouldn't have to imagine that the legislature would explicitly state that the purpose in passing mandatory minimums is to remove people who are committing crimes. And again, there's a lot of data on this. The small number of people committing the vast number of crimes. You take out perhaps 10% of offenders, and you're removing something like 70% of offenses, at least in certain categories of offenses, particularly those involving violent crime. That this used to be taken for granted. Now it has to be put front and center. And you have to somehow justify that this is properly balanced against the rehabilitation of offenders. And I'd just like to refer very briefly to Bisonet, because it makes this point. You have the Quebec City mosque shooter. And Chief Justice Wagner, in the reasons for the court, he says, well, we understand the possibility of rehabilitation of this offender is remote. I'm sorry, it's not remote. It is non-existent. You cannot rehabilitate somebody who murdered 6 people at prayer. It is completely impossible. But somehow the court just takes this position that to say that, to kind of give voice to this balancing, which says, no, we have to incapacitate, denounce, punish these individuals. It's just somehow something that needs to be the subject of a legal fiction that says rehabilitation is always possible and in fact should always have priority.
Right. Yeah. So let's get into the nature of the tests and judicial interpretation and how meanings of words maybe are even changing here. But before we do so, with respect to mandatory minimums, I want to seize upon what's going on here. What are the courts finding objectionable in addition to some of those things you've just mentioned? One perhaps is the fact that maybe they're overbroad. It's a mandatory minimum, so by definition, it's more or less exceptionless. I think, NCR, not criminally responsible, would still apply and some other things, but more or less there are no exceptions. So you can conjure up scenarios in which, well, maybe, okay, there should be some sort of exception here. And so it seems like on that basis, judges are saying, well, that under our interpretation of Section 12 and those sections, this must be cruel and unusual or what have you, or a charter violation. And, in looking into this further and coming from the public safety space, I do understand that Canada's a bit unique in this regard in that we don't have exceptions to mandatory minimums. Some other countries do, and they're very narrow. But I wonder, like, does that fix the issue? So on the one hand, you could say, like, the court could strike something down because they think, well, it should have an exception because of our interpretation of the charter. But on the other hand, you could say, well, is it the court's, like, how does the court actually have the right or the jurisdiction to do that? What are your thoughts about changing mandatory minimum policy here and how it's being interpreted?
I mean, I've seen some really thoughtful work on this by certain political scientists, very intelligent policy proposals in this area. But I would say that just as you set up the problem, I want to push back a little bit, because we have to remember that this is a convicted offender, right? And in our criminal justice system, they have the benefit of so many defenses at the liability stage. So look at what the Supreme Court of Canada has done with respect to extreme intoxication, what it's done with automatism, right? That it used to be the case that you could say, look, the mens rea here for the offense, like you committed a homicide. Well, you did it while you were blind drunk. We're going to say that the intent to commit the homicide is effectively formed at the moment when you became incapable of restraining yourself, especially in a situation where the person knows that they are extremely violent when they consume extreme amounts of alcohol. Supreme Court has said that's unacceptable, right? So now somebody who's gone through this system where they get the benefit of every rule that says the burden is on the Crown, and I think we'll come back to this point when we refer to bail and sentencing. The burden is on the Crown to overcome all of these possible defenses. They have every benefit at every stage, and then they come up against a mandatory minimum. Now, so that to me, that kind of sets up the problem. And now we see a situation where many, many people in academia are saying that the time is ripe for the mandatory minimum for premeditated murder to be struck down. Now think about this. The idea is, well, in some circumstances, that 25 years, right? And of course, parole is built into this. There's a possibility, it's highly structured, right? But the notion that the presumption effectively is 25 years of incarceration for premeditated murder is unacceptable to them, because the notion is, well, it might be unfair in particular cases. But think about how that needs to be balanced against the incentive for denunciation, the incentive for general deterrence. The idea that if you can present a compelling enough life story to a justice, perhaps about trauma that you experience, perhaps intergenerational trauma, that would mean that you're not subject to that. How is that going to affect things more broadly? Now, you see no sense in the courts or among the activists who are pushing for these changes that criminal justice involves trade-offs, and that people are going to be affected other than just the offender. It's going to change the entire landscape of crime and criminality, just as we're seeing now with 17-year-olds, 16-year-olds being brought into more serious roles within organized crime because they have the benefit of extremely lax youth justice rules. These are incentives, and people will respond to incentives. If we have this incredibly narrow focus on doing justice to the convicted criminal, we're losing sight of the fact that there is necessarily a balance here. But that's what we're seeing in the jurisprudence.
Yeah, and I think, like, ultimately, if it is the legislature that passes the laws and the courts are to interpret them, so there must be some deference there. We're going to get into how the charter and how this balancing and trade-offs end up leading to these results, as well as some of the tests and how words change their meaning and what have you. So let's do that. Another thing you point out in your piece are the types of tests that are being employed here. One of which is this hypothetical offender standard. So I'd like you to explain that for us. And also just comment, is this a broader trend in law? You hear of social science tests being employed, which is basically what this is. It's conjuring up a hypothetical scenario and saying, well, a policy could contribute to certain social outcomes for groups under certain circumstances even, and that this therefore makes them fall afoul of a common law precedent or a charter value. And I think the question for me is whether courts should be turning to this kind of vague, unpredictable social science to justify their judgments. Are legislators legislating on the basis that the law should only apply if it results in some hypothetical social outcome? Oftentimes, and certainly in the case of crime and punishment, as you're saying, deterrence, denunciation, all of these sorts of things are the motivating reasons for the law. And these other considerations don't really have anything to do with this. So just in summary, what are your thoughts on the types of these hypothetical tests being employed and in the use of social science in judicial rulings more broadly?
Well, the use of social science is very problematic. It's brought in under this rubric of social facts evidence. So you have a sociologist coming and adducing the study and saying, well, this proves this would have this kind of effect. You've seen quite a lot of this in cases involving prostitution, challenges to that are Section 7, also in terms of medical assistance and dying, to use that phraseology. And the problem is that it's highly speculative in nature. You look at it and you push back on it and you say, well, we have really complicated rules of evidence that govern the admissibility of certain things. And you look at how this is so important to the administration of the criminal justice system. And now you create this giant loophole just because it's being brought in by somebody who is purportedly an expert, that they can essentially say, I can see the future, right? I mean, it's really interesting. I'd like to ask some of these social scientists, why don't you get involved in investing? Because if you could see the future, you'd be a billionaire. And again, I mean, thinking about how these social scenarios play out, there's certainly an economic dimension to it. What are you doing working at a university? You should be at a hedge fund. So I see this as highly speculative in nature. The courts have developed this jurisprudence that allows for it. I think it wouldn't be allowed if it wasn't so useful for the courts to achieve their preferred policy objectives. But now when we turn to reasonable hypothetical as the test for Section 12, infringements, and I think you're alluding to that, what you see is it's not even evidence at all. So it's pure speculation. It's not even coming in through the parties many times. It's a justice formulating a thought experiment. And I think this really shocks people. So I think it's worth describing this in some detail. What happens is an offender is sentenced, and everyone agrees that based on the facts of this, so let's just use the recent decision of the Court of Appeal on sex abuse of a minor under 16 as the example. This was on the facts, at the very least, considered to be a forcible rape of a very, very vulnerable individual. So this girl, and let's use this language, this girl who was 14, who shows up and is the subject of coercive, forcible sex by an adult, right? Everyone agrees that the sentence that was given to that particular offender is fit and reasonable. There's no dispute. There really couldn't be any dispute. But the problem is, now we have a green light, and this came from Madam Chief Justice McLaughlin, as she then was, in a case called Noor from 2015, right around the time of this explosion of problems in criminal justice, or let's just say of criminality, right around that time. They say, well, now we can still strike down the mandatory minimum, even though in your case, it wouldn't have even applied, because what you did was so serious that you would receive a sentence far in excess of the mandatory minimum. The problem is, I, as a judge, can imagine hypothetically an offender who was so sympathetic, because there's really no limit on judicial imagination, that this mandatory minimum would seem somehow to be cruel and unusual when applied to that person. So on the basis of an imaginary potential future criminal defendant, we are going to strike down this mandatory minimum. Now, some of these hypothetical examples are outlandish. And they're the kind of examples where you say, well, these are the people, precisely these people, who would have the benefit at every stage of the criminal justice system before punishment. They would be able to advance defenses. There would be prosecutorial discretion. There would be all of these possibilities. The notion that now they're at sentencing, some judge is going to say, I'm sorry, the legislature has tied my hands. This is the most sympathetic case I could possibly imagine, anyone could possibly imagine, but I'm still required to sentence you to 1 year in prison for sexual abuse under 16, of a minor under the age of 16. It's outlandish. But again, we've moved from the acceptance of very speculative social facts evidence to rampant speculation on the part of judges as a means of striking down laws. These are laws that are enacted because of the particular consideration of actual facts by people who are responsible to an electorate. And now you have that law being struck down because some judge can say that, well, hypothetically, I can see how this would violate someone's constitutional right, after that constitutional right has been inflated beyond all measure by that court's jurisprudence. And I can certainly talk about how that's happened with respect to Section 12.
Yeah, very good. Thanks, Ryan. I think that so there are two issues there as you've just drawn out. There's the first, which is this, it's like they're not judging the law and the facts of the case in question at present. It's extrapolating to potential other scenarios. So it seems very clear to me from this type of test that the court is going beyond its primary role of, interpreting and enforcing the law to changing policy into, deal with some future highly hypothetical scenarios. So that's one thing. And then now we'll talk about this second issue of how the charter is being interpreted and other statutes and what sort of principles are in play here. It seems to me that another theme here is concept creep. Is there, a clear public meaning at the time of the legislation, or a definition in statute or the charter to appeal to when attempting to understand the meaning of the things that are the subject of the interpretation, and then the trade-off of competing values that are at stake in cases like these, things like human dignity, like compassion or fairness, cruel and unusual even, right? Like those are obviously two key terms in terms of how these concepts are being interpreted and used to justify the overturning of mandatory minimums and other legislation.
Brilliant question. And I said the way you set it up is also extremely perspicacious. So you have this balance between these opposites, right? This notion of dignity and this notion of cruelty, this notion of punishment and this notion of liberty, right? And these are all really important terms that political philosophy has to grapple with. When we have a society that has an agreement on these terms, we have clear and objective interpretation of them. The problem is there's been a really rapid social change, at least in certain segments of the population, as to how we approach these fundamental issues. And you see this coming out in the judicial decision making. And I don't think that we should see that abstracted away from this sort of broader social change in particular ways. So originally, this is quite important. I've done a lot of work in this area, I would say, to kind of flesh this out. The concept of what is cruel and unusual had a narrow, fixed meaning. And this is not just going back hundreds of years, but it does in fact go back hundreds of years. But well into the 1970s, when we had this parallel provision prohibiting cruel and unusual punishment under Diefenbaker's Canadian Bill of Rights, it was interpreted by the Supreme Court of Canada. And they said, okay, no, the length of incarceration can never be the basis for saying that something is cruel and unusual punishment. That it doesn't figure into that analysis, because here the problem is we understand what this means, cruel and unusual, right? The first initial change in the concept creep was to say it's cruel or unusual. So you have, for instance, flogging in Kingston Penitentiary. You say, well, that's unusual punishment. We're not going to allow for this, right? It would have met the test for cruel and unusual punishment, for sure, under the Canadian Bill of Rights. But now you have this notion of cruelty kind of unmoored from its fixed historical meaning. And the problem is, cruelty is kind of central to the liberal imagination in a certain way. This notion of dignity and this notion of cruelty have been transformed, right? So when you see Bissonnette, when Chief Justice Wagner says, the dignity of someone is impaired when they're facing the possibility of a natural life sentence, that the notion that they could never be sufficiently rehabilitated in the view of the authorities to be released from incarceration is harmful to their dignity. Now, I mean, when we think about dignity in a more classical sense, we would say the idea that someone says, I accept my punishment. I accept that it is just that I murdered 6 worshipers at prayer, right? That I have to atone for this my entire life. I will never be able of doing anything to make that balance sheet clean. So I accept this. That is where my dignity comes from. It's from the fact that I engage in this process of reflection, acceptance, and self-transformation. Not someone asserting a claim and saying, I demand to be treated with dignity, as if they have to do nothing to deserve it, right? This notion of a right with no obligation attached to it. It seems to be really kind of central to what people have described as the left liberal imagination, right? So now you have that the concept creep where now cruelty, the notion that someone isn't being treated with perfect fairness, the notion that, well, yes, you did commit sexual abuse of a minor under the age of 16, which is horrific, right? I mean, we have this mandatory minimum as an expression of denunciation, saying that under no circumstances should you be able to excuse this. I mean, let's just assuming on the front end that you haven't been able to establish, let's say, extreme intoxication, right? So the benefit of this. But given all of that, we're not interested. We don't want to hear that for some reason. And so they've offered all kinds of reasonable hypotheticals, quote unquote, for this. We're not interested, right? But in the mind of the jurists, this is cruelty. The notion that someone somehow is not getting the platonically ideal sentence for what they did. Instead, they're getting 1 year for something which is in every circumstance horrific and unacceptable. Understanding that concept creep is probably a bit outside of the scope of what we're doing here, but I think it's actually vital to investigate.
No, yeah, you've really illustrated it well, how the meaning of core terms, central to the judicial interpretation here, are shifting very quickly in some cases over time. And, if anything, the law is meant to be the law. And then, you change the law and the meaning of the words through the legislative process if those things need to be changed, but not kind of through the back door, if you will, right? Through the process of judicial interpretation.
If I could just hop in too, there's that problem, and there's a problem that is uneven. So this notion of fairness, take a look at how that's applied in administrative justice when somebody faces the loss of their professional license, right? And I know this is something that MLI is really interested in. Mm-hmm. What you get in terms of fairness there is the kind of fairness that comes in under the administrative law standard. That's the standard for the law abiding, right? This is somebody who hasn't committed a criminal offense. It's just someone who's done something that someone out there in the public has found to be somehow problematic or offensive. Think about how the burdens work in this administrative notion of fairness. It's really the absolute minimum. Whereas you have somebody who has been convicted of an offense, and now at the phase of sentencing, they have to have transcendent fairness. Whereas previously, and this is very much still the case in the United States, at that stage, when it's not about whether or not you have committed the crime, you get essentially natural justice. And again, a clear meaning, right? You have the right not to be prosecuted by somebody who was also the judge, or vice versa. And you have the right to be heard. Audi alteram partem, right? Both sides have the right to be heard. And that's been expanded beyond all measure in one area to include all of these process protections, and in others, practically nothing. Think about when you're hauled before an administrative tribunal on pain of loss of license, whether or not they provide a lawyer for you, a great expense to the public. The answer is obviously no.
Yeah, indeed. Much more we could dive into on this subject, but let's now make sure we get to what is really, the more substantive part of your work, or at least alluding to what could become much more front and center in the public domain in months to come. And that's the Notwithstanding Clause. And I want to talk about judicial reform more broadly, because you've laid out the issues here that are in question and what may be motivating. We've seen the Notwithstanding Clause, as mentioned earlier, be used more frequently in recent years. So let's start with some basics, though. Brief description. What is the Notwithstanding Clause? Why was it adopted? How has it been used to date, including in just recent years?
So the Notwithstanding Clause is actually fairly limited. It allows a legislature, which is to say either parliament or a provincial legislature, to pass a law, and then to say when it passes that law that it will operate notwithstanding a challenge based on a particular charter right or set of charter rights. So what you might do, hypothetically federally, is pass a law with a mandatory minimum and say this will operate notwithstanding Section 12, which is the cruel and unusual provision of the charter. And what that does is, for 5 years, it's impossible to have that law struck down for offending against that charter provision that is referenced in the text of the act. So it's actually very limited. It has both that restriction as to what it derogates from, to use that language, and then in time. And the time provision is quite important because effectively that's the length of, or at least the very maximum length of a parliament. So for instance, if a new federal government put in a bill of the type that I've just described, it went through very expeditiously. By the time of the next election, that 5-year period would be on the horizon. Somebody could say, Canadians are having their rights impaired by this. Their Section 12 rights, as they are interpreted by the Supreme Court of Canada, right, are now impaired by the operation of this bill, notwithstanding that jurisprudence. This is really unfair, and that's why you should vote for my party. So it's actually quite limited. And sorry,
why was it adopted? Why was it adopted? Some recent uses, just brief examples.
Well, I think that the most critical portion of this is it was a necessary precondition for the charter. There would be no charter if the premiers hadn't been assured that they didn't have some kind of an insurance policy against precisely this. They were afraid of judicial inflation of rights, and they were afraid that their legislation would be struck down in various areas. I mean, Quebec and language rights would be one clear example of that fear, kind of motivated in that process. So they had to accept this. And Pierre Trudeau, there's a very famous exchange between him and his then Justice Minister, Jean Chrétien, where Pierre says, you should never have given them that. And Jean Chrétien says, I'm sorry, Pierre, you gave them that. You gave them that. You knew that was what you had to do to get the Charter of Rights and Freedoms. So essentially, from day one, everyone understood that judicial inflation of rights was a problem. There had to be some kind of mechanism to impair it. And I would say it's really important to recognize that when that was a very real threat, courts responded to that. They knew they were kind of operating in the shadow of this. They knew that if their interpretation of charter rights became outlandish, or perhaps more so, that they were going to face this kind of pushback. So it was the very basis for the charter itself.
So I think you've answered some of my next question here, but why is it really important to have a clause like this in the Constitution, notwithstanding, for no pun intended, the fact that, the way you've described it here, it was somewhat of a trade-off between competing interests. I think valid ones, though. So you can just elaborate on that. Why is it important? And then how ought it be used?
Right. So I guess the problem is that the charter without it isn't the charter. The charter without it is just too strong of a document. What it does is it effectively relocates the center of power from Parliament to the courts. They become the Platonic guardians of Canada's legal order. And that really does damage to them as well. Effectively, what it does is it preserves this notion that there is some sort of system of checks and balances. We shouldn't think of the judiciary as somehow exempt from this. I mean, to use a pop culture reference, right? In The Lord of the Rings, the most moral people refuse to accept the One Ring. Frodo offers it to Galadriel, right? And she says, look at what that would do to me if I accepted this, right? It's very much the same. There are no people exempt from this notion that absolute power corrupts absolutely. The fact that they wear robes doesn't exempt them from this. Sometimes it, in fact, exacerbates the problem. So to have a system of rule of law, we have to have checks and balances. There can be no one who assumes this completely unaccountable role. So how should it be used is an interesting question. I would say it's not really a safety valve. It's not that it's there just because, oh, well, when we finally reach this crisis period, it has to be the final emergency brake or whatever metaphor you want to use. It has to be used to tell the courts that there's been a determination made that the problem that legislation is addressing is so serious that it needs to operate notwithstanding this right. And I would say this is integral to law. To see this as somehow a breakdown of the rule of law, do we think that that the International Convention on Civil and Political Rights is an instance of the breakdown of the rule of law? It contains derogation provisions. It says in a situation where it is so serious that you need to break even the most basic human rights law protections, aside from a very small number of non-derogable ones, right? Those exist also in Canadian law because they're outside of the scope of what Section 33 contemplates, that you can do this. So there will be problems that are so severe that legislation has to address them, notwithstanding certain charter rights. And I would argue that right now, what's happening with crime and the blight of this endemic crime in Canadian communities clearly meets that description.
Very good. Okay, so we've covered a lot of ground here, from statutory interpretation, constitutional interpretation, how the philosophy of it is changing, how it seems to be much more loose. We've covered also imbalances now in jurisdiction and scope of power. And so I just want to ask you, what in your view, like how has it come to this? How has it gotten so out of whack?
I think that, well, a book I normally recommend to young people. So when I'm talking to people at Running Meat chapters, I mentioned a book by Thomas Sowell called The Vision of the Anointed. I think it's really central to getting people's perspectives on this aligned correctly. The problem is we don't recognize that policymaking, as is done by legislatures, is a process of trade-offs, not a process of solutions, right? The idea that somehow we're going to solve crime in particular ways is very attractive to certain people. For a really long time, part of what you would call the left liberal imagination was this idea that if only we could educate criminals or potential criminals adequately, they wouldn't be committing crimes. You could find many, many examples of statements to that effect, right? So if we just went into prisons and somehow people really understood that when they commit violent crime, they're hurting people, they just really were fully able to grasp that. When they were released from prison, they would no longer commit crime. This really is a fantasy world. I'm sorry. I mean, if you have any real exposure, and this, of course, I think is why the majority of the Canadian public rejects this vision, is because when you have real contact with people who engage in violent crime, you start to understand that that is a very desirable. And there are people in that group who will do that. And I would say the critical part of that is the acceptance of responsibility. Invariably, in my experience, the same people who would say, it's fine that I'm not released from prison, are the ones who can be released from prison, right? Because they understand this, and they understand that it's right that they be punished for what they did, and that they shouldn't be the judge of how that punishment should be inflicted. But nevertheless, this notion that crime can be solved